The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon, and welcome to this session of the Kansas Supreme Court. I will ask Mr. Doug Shima to please call the afternoon docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Friday, April 2nd, 2021 consists of two cases. First case to be heard on the docket, appeal number 123423, in the matter of Brent E. Lindberg, original action in attorney discipline, no briefs filed. The second case immediately following will be appeal number 123203, in the matter of Mark G. Ash, original action in attorney discipline, briefs both sides. The disciplinary administrator has reserved 2 minutes rebuttal in each case. Your Honor, we are ready to proceed.
And Mr. Shima, can you confirm that Mr. Lindberg is not in the waiting room and is not signed on for the Zoom hearing?
I can confirm that, Chief, and we will monitor the waiting room during the argument.
Okay, thank you, Mr. Shima. With that then, Mr. Hazlitt, would you please state your appearance?
May it please the court, Stan Hazlitt, appearing for the Disciplinary Administrator's Office.
And Mr. Hazlitt, if you would like to begin your argument and advise us about service of Mr. Lindberg, we would appreciate that. Thank you.
Thank you, I appreciate it. I did not check on the service because Mr. Lindberg, I think Mr. Shima can confirm this, appeared at the practice session. Now he was gone about halfway through the practice session, but he was there at the beginning of it. So my assumption is that he has notice of this hearing as well. I'll give you a little background on this case. April 4th of 2018, Mr. Lindberg self-reported to our office. He advised us that he had been charged in Johnson County with felony possession of methamphetamine and misdemeanor possession of drug paraphernalia. The charges were filed on March 20th of 2018. On August 29th of 2018, the respondent entered into a diversion agreement for both charges. On November 19th of 2018, this court temporarily suspended the respondent as a result of that diversion agreement for the felony offense. I discuss a little bit about how this disciplinary case progressed. We had a hearing on August 29th of 2019 at which the respondent appeared pro se. The day before that hearing, we received notice from Johnson County that the district attorney there had filed a motion to revoke the diversion of the respondent. And the allegations were failure to submit to 2 urinalysis tests, testing positive for amphetamine on 4 occasions, testing positive once for methamphetamine, and 1 positive test for alcohol. At that hearing on August 29th, the respondent disputed these allegations and said he was going to contest them. He suggested that he was then living in North Carolina. He suggested that the lab where he submitted to the testing in North Carolina was faulty, had made some mistakes. He also indicated that he had a prescription for the amphetamine. The panel reset the hearing until April of 2020, thinking that the criminal case would be concluded at that time. And due to the pandemic, the April setting was continued and a Zoom hearing was set for October 5th of 2020. Prior to that time, the criminal case had been resolved. On November 22nd of 2019, the respondent's diversion was revoked. He stipulated to all of the allegations in the motion to revoke, although at that hearing, he still took the position that he had not really violated those conditions, but that he went ahead and agreed that he had done so based on the advice of counsel. On July 8th of 2020, there was a court trial on the stipulated facts. He was found guilty of possession of methamphetamine and the paraphernalia charge. He was sentenced to 6 months and granted probation. It's my understanding that he successfully completed the probation. And so what we have really is a diversion, a violation of the terms of that diversion, and a subsequent felony and misdemeanor conviction. He was found to have violated KRPC 8.4b as a result of the criminal convictions and Supreme Court Rule 211 for his failure to file an answer. I think he testified at the first hearing that since he was going to come here and admit everything, he didn't have to file an answer as required by the rule. He did not take exceptions to the findings of fact or conclusions of law. there was one aggravating factor I would like to mention to the court. That's under the category of submission of false evidence, false statements, and other deceptive practices during the disciplinary process. The panel noted inconsistencies in his testimony that at the August 29, 2019 hearing, he testified that he had not had any alcohol previous to that hearing pursuant to the terms of his diversion. But at the diversion revocation hearing, he admitted he had consumed alcohol on August 2nd of 2019. Panel found his testimony at the August 29, 2019 hearing to be false and designed to deceive the panel in that case. The recommendations made at the first hearing were really not relevant because at that time his diversion had not been revoked. So at the October 2020 hearing, the respondent really didn't make a recommendation. We recommended indefinite suspension, but if the panel found the respondent to have been dishonest in his testimony, we recommended disbarment. The panel recommended suspension for 2 years, reinstatement, at which time there would be a reinstatement hearing, at which the respondent would have to prove that he had no drug usage for 3 years, successfully completed probation, had complied with alcohol and drug treatment, not violated the law, and paid all these fees and his CLE requirements. They wanted the suspension to be effective the date of the court's opinion. What I was going to say, if the respondent were here, was that I would change my recommendation to what the panel recommended, because in effect, what we have here is the respondent has been temporarily suspended for about 2.5 years. And if he were suspended for 2 more years with a reinstatement hearing, it would be close to 5 years, which is the amount of time you are suspended or disbarred before you can apply for reinstatement. If there's some glitch here, if there's some explanation why the respondent is not present here, I would recommend that the panel's recommendation be followed by the court. If it's just a matter of not showing up, I think that's an aggravating factor, and this court has recognized that as an aggravating factor, and I would recommend disbarment for under those circumstances. Be happy to answer any questions.
You're recommending disbarment in that as an aggravator, but for lack of a better way to put it. But weren't you going to recommend 2 years? So wouldn't that be indefinite? I'm not certain what you were going to recommend.
Yes, I was going to go
2 years if there's some excuse that he's not here, right?
If he were here, I was going to recommend exactly what the panel recommended, a 2-year suspension beginning at the time of the court's opinion, with the conditions that they recommended that he be required to show if he went through the reinstatement process. But it seems to me now, if in fact he just decided not to show up, and I believe he's been notified of this hearing, I think under those circumstances that I do believe that disbarment is the appropriate discipline.
Okay.
Any other questions? Thank you, Mr. Hazlett. The court will take this matter under advisement.